And if I could ask the clerk to call the roll, please.
Senator Barfoot,
Here.
Senator Bell,
Here.
Senator Chastain,
Here.
Senator Figures,
Here.
Senator Livingston,
Here.
Senator Orr, Senator Roberts,
Here.
Senator Schofield, Senator Singleton,
Here.
Senator Smitherman,
Here.
Senator Williams,
Here.
Representative Allman, Representative Boyd,
Here.
Representative Carnes, Representative Klaus,
Here.
Representative Ellis,
Here.
Representative England,
Roll Tide.
Roll Tide, Representative Hall, Representative Jones, Representative Levern,
Here.
Representative Pringle,
Here.
and Representative Reynolds.
Here.
We got 21 present. We have a quorum.
21 members being present, we do have a quorum. Mr. Chairman.
The next item on the agenda is election of co-chairs for this committee. Do I have Representative Klaus?
Representative Pringle, I nominate Representative Pringle for chairman.
Co-chair of the House. Do I have a second? Do we have a nomination for? Yes.
I'm ready.
Yes, Senator Figures.
Mr. Chairman, thank you for the recognition. I think in light of us having coming back here for this reason of redrawing the congressional lines for the state of Alabama, coming from the court case, I think that it's important that we show diversity in our chairmanships. And I think it would send a great message of, in the spirit of fairness and in the spirit of bipartisanship, that we have one chair from the House who is one chair from each House, if you will, be a minority. And I would like to yield to Representative Hall for that nomination for the House co-chair.
And I'd like to nominate Chris England.
I second.
We have a motion and a second. We have a motion to close nominations on the House co-chair.
So move.
We have a motion and a second. Now we have do we just want to vote on the House? You want to vote on the House first?
I guess we do.
I'd like to have a roll call vote, Mr. Chair.
We have a roll call vote on the House co-chairman. The clerk will call the roll and you'll announce, the members will announce who they're supporting.
Mr. Chairman.
Yeah.
Point of order. Who are the candidates that?
It would be me and Representative England.
Okay, so the vote would be mentioned Representative England or Representative Pringle?
Yes, for the House co-chair. Then we'll elect a Senate co-chair.
Thank you, Mr. Chairman.
And I'm just asking that one would be a minority and the other one would be a majority, or if you will, one a Democrat and the other one a Republican.
I second.
Well, you heard the motion. The clerk will call the roll and the members will announce their vote for either Pringle or England.
Senator Barfoot,
Representative Pringle.
Senator Bell,
Representative Pringle.
Senator Chastain,
Representative Pringle.
Senator Figures,
Representative Chris England.
Senator Livingston,
Representative Pringle.
Senator Orr,
Representative Pringle.
Senator Roberts,
Representative Pringle.
Senator Schofield,
Representative Pringle. She's going to be getting some.
Senator Singleton,
Representative England.
Senator Smitherman,
Representative England.
Senator Williams,
Representative Pringle.
Representative Allman,
Representative Pringle.
Representative Boyd, Carnes, Representative Klaus,
Representative Pringle.
Representative Ellis,
Representative Pringle.
Representative England,
Representative England.
Representative Hall,
Representative Chris England.
Representative Jones,
Representative England.
Representative Laverne,
Representative Pringle.
Representative Pringle,
Pringle.
Representative Reynolds.
Representative Pringle.
Is 14-7 for Pringle.
Thank you, ladies and gentlemen. The next order of business is elect a Senate co-chairman. Do I have floor is open for nomination? Senator
Chair,
Bill? Yes, Representative Hall.
I'd like to nominate Senator Singleton.
We have a representative for,
I second.
do we have a second on Mr. Livingston?
Second.
Yeah. We have a second? Yeah.
Yeah, second.
Yeah, we got a first and second on. The question now is on Senator, who was this? Senator Singleton, you got me, or Senator Livingston. The clerk will call the roll. Those in favor of Livingston will say Livingston, and those for Singleton will say Singleton. Clerk, call the roll.
Senator Barfoot,
Senator Livingston.
Senator Bell,
Senator Livingston.
Senator Chastain,
Senator Livingston.
Senator Figures,
Senator Singleton.
Senator Livingston,
Livingston.
Senator Orr,
Senator Livingston.
Senator Roberts,
Senator Livingston.
Senator Schofield,
Senator Livingston.
Senator Singleton, Senator Smitherman, Senator Williams, Senator Williams,
Hey, I'm sorry. Livingston.
Did you say Singleton?
No. I was looking at my map.
Representative Allman,
Use for a minute.
Representative Boyd,
Singleton.
Representative Klaus,
Senator Livingston.
Representative Ellis,
Senator Livingston.
Representative England,
Senator Singleton.
Representative Hall,
Senator Singleton.
Representative Jones,
Senator Singleton.
Representative Lovern,
Senator Livingston.
Representative Pringle,
Senator Livingston.
Representative Reynolds.
Senator Livingston.
There's 14-7 for Livingston.
Moving on, the next item of business to review and approve the minutes from the last meeting. They're inside your packet. So do I have a motion? I have a motion. Do I have a second? I have a second. All in favor, say aye.
Aye.
Like sign, nay. Minutes are approved. We'll talk about the schedule.
I'd like to thank everybody for being here today. I'd like to remind everybody that July the 7th at 5 p.m. is the deadline to submit plans to the committee. I believe we already have over 100 from as far away as France. So we were processing them as fast as possible, and we will talk about those at the next meeting, which will be July the 13th in room 200 here. Yeah, and if you're submitting a plan, we need your name, your address, and your phone number. And if you're submitting on behalf of another organization, we need the name of that organization, its address and phone number. That way, if we have any questions from the committee, we'll know who to contact to address those questions. As you know, yes, Senator.
Will we adopt, wait until that July 13th meeting to adopt or whatever the next meeting?
We had on the agenda today to adopt the guidelines.
Okay.
Yeah. Yeah. Anyway, we'll discuss the guidelines today. And as you well know, the governor has called a special extraordinary session for July 17th to start. After that session, the plan will be presented to the federal court in Birmingham on August the 14th. And then we'll have a hearing in Birmingham when the court schedules it. But this is just one of many steps that we have to go through on this process. You want to do let's just talk about it. Everybody on the committee has been given a copy of the guidelines. We ask you to please review those guidelines. Since today is just a public hearing, we're not going to adopt anything, but we do want to we want you to read the guidelines, review them, and we'll discuss them and we'll vote on them in the next meeting. So that gives you plenty of time to look at them and review them.
Mr. Chairman,
Yes, ma'am.
so am I looking at what's the heading that you're guiding? What's the date?
Reapportionment Committee Redistricting Guidelines,
What's the date? You have a date on there?
May 5th, 2021. Yeah, they're carried over from the last adopted guidelines. That's the reason we want everybody to read them and look at them. Yes.
Looking at these, but they seem to me to be the,
Will you please turn your microphone on?
hand it on.
No. There you go.
Thank you so much, Mr. Chairman. I'm looking at these dated May 5, 2021. These are the ones that we had last time. My question is, how do these differ in any way from those we used before, if they're the same or what?
They're the same. We gave you the ones that we had adopted last time for your review and input, and we're going to talk about them and vote on them next time.
Well, I'm saying this because I already had a copy of these from last year, and I just wanted to make sure that I'm on the right page.
Yes, ma'am.
Start off right.
Yes, ma'am.
In unity instead
Yes,
of
ma'am.
the way we are. Thank you.
We're not hiding anything. These are the existing guidelines, and we want everybody to look at them and review them, and we'll talk about them next time.
And
Yes, sir.
Will there be, I guess there will be some sort of procedure that we'll adopt if we're offering amendments to these guidelines?
We're going to have a meeting to discuss them, yes, sir, in the next meeting.
It would seem to me that it would be important for us to try to change the procedure, considering the initial procedure got us in a little bit of hot water. So maybe over the course of the next couple of weeks, we could take a look at these guidelines and see if there's some things that need to be tweaked so we can avoid ending up back in court for doing the same thing and expecting a different result. So, do I need to submit any changes to these guidelines in writing prior to the next meeting, or do I need to wait till we get here?
It would be helpful, yes, sir. That way we can have the lawyers review the changes to make sure they're compliant with the Constitution and Section 2 of the Voting Rights Act.
Thank you.
Yeah. I mean, we want input. Everybody to look at it, everybody read it, and if you got a suggestion, make a suggestion. So we'll be glad to look at them.
also like to point out the big white sign in the back of the room that's got, if you have questions or comments, it's got an email address you can send to it. So if the cameras could catch that, it would be greatly appreciated.
Yeah, we need to get that sign up front, and we need the sign up sheet. If we can get that email, we want the people, we're going to live stream this meeting, the public hearing, so everybody can watch it. And we want that email up front so anybody watching can send an email, comment in, or ask a question. The clerk will read to us.
Thank you.
Thank you. But I need the clerk to bring me the sign up sheet for the public hearing. Thank you. Mr. Walker, are you ready for the public hearing? All right, come forward.
You want me to sit down here?
Yeah, we'll need a microphone for you. So, let me, I know Mr. Blackshear's here. I've seen him, and he's an attorney representing some of the plaintiffs. And I want to give great deference to the attorneys. There are any attorneys here representing plaintiffs? Will you raise your hand? Is there anybody here representing one of the plaintiffs that's not an attorney? Okay. Mr. Blackshear, would you like to kick us off today?
I need a little preamble before we start.
Okay.
Am I on? Yeah. Good afternoon and welcome to this hearing. My name is Dorman Walker. I'm a lawyer who represents the Reapportionment Committee. I'm the committee's hearing officer for this hearing. The committee has two chairs, Senator Steve Livingston is the chair for the Senate, and Representative Chris Pringle is the chair for the House of Representatives. The members of the committee are Senator Barfoot, Senator Bell, Senator Chastain, Senator Livingston, Figures, Senator Livingston, Senator Orr, Senator Roberts, Senator Schofield, Senator Singleton, Senator Smitherman, and Senator Williams. And also Representative Allman, Representative Boyd, Representative Carnes, Representative Klaus, Representative Ellis, Representative England, Representative Hall, Representative Jones, Representative Loveborn, Representative Pringle, and Representative Reynolds. Following the release of the 2020 census, the Alabama legislature enacted new districts for Alabama's members of Congress. The new congressional districts were challenged in federal court by 3 lawsuits: Singleton v. Merrill, which challenged the new congressional districts as unconstitutional racial gerrymanders; Castor v. Merrill, which alleges the new congressional districts violate Section 2 of the Voting Rights Act; and Milligan v. Merrill, which alleges the new congressional districts violate both the Constitution and the Voting Rights Act. In 2022, a federal trial court in Birmingham entered a preliminary injunction forbidding the state from using the new congressional districts. The basis for the trial court's ruling was its preliminary determination that the new congressional districts violate Section 2 of the Voting Rights Act. The trial court did not address the argument that the new congressional districts are unconstitutional. On June 8, 2023, the United States Supreme Court affirmed the trial court's preliminary ruling. This means that the new congressional districts must be redrawn in a way that complies with Section 2 of the Voting Rights Act. At the 2022 preliminary injunction hearing, the Castor and Milligan plaintiffs introduced 11 proposed remedial plans. The Singleton plaintiffs had previously introduced 3 proposed remedial plans. Additional remedial plans were submitted in amicus filings to the Supreme Court, and more recently, after the announcement of this hearing, including a new remedial plan jointly proposed by the Castor and Milligan plaintiffs. The purpose of this hearing is for the Reapportionment Committee to take public comments on a potential new map. Speakers may reference any plan that has been submitted, but they do not have to reference a particular plan. Speakers will be called to speak from the list of persons who signed up before the hearing. If time allows, after all of the registered speakers have been called upon, I will ask if anyone else wants to speak. So if you did not sign up but have now decided you want to speak, I'll try to give you an opportunity to do so. When your name is called, please come up to the lectern to speak. It's important to be able to enable the court reporter who is not physically present to be able to hear you. When you start to speak, please identify yourself by stating your name for the record. Please limit your comments to the topic of this hearing, which is how new congressional districts should be drawn. Because the purpose of the hearing is to take comments, committee chairs will not take questions, or the committee members will not take questions. Each speaker will have 3 minutes. I will give you a 1-minute warning. Persons listening to this hearing remotely may submit by email comments to be included on the record using the email address displayed near me. That is district@alsenate.gov. That's district, district @alsenate.gov, G-O-V. Before I call the first speaker, I will add to the record of this hearing a letter jointly submitted by the Castor and Milligan plaintiffs in support of their jointly proposed plan, which will be exhibit number 1 to the hearing transcript. And I don't have the list of people who signed up.
Call them.
Okay.
Just a point of order to kind of, there's some confusion about because I want to make sure the record is clear. There are the plaintiffs in the case that got us here today are the Castor and Milligan plaintiffs, correct?
Yes, sir.
Okay, because there was some mention about the Singleton map, but that is not an issue we're talking about today, correct?
The Singleton map is on the agenda today. Yes.
Well, no, I guess what I'm asking is because it appears that the plaintiffs in the relevant case are the plaintiffs from the Milligan, and Castor, and those were the maps that were provided also, correct?
Correct.
All right, because I just want to make sure the record is clear that the Singleton map and that plaintiff is not a party to what we're doing today.
But the Singleton map was introduced as a bill, and I understand, but the plaintiff's attorneys did not show up. Now, nobody from the plaintiffs are here.
Mr. Chairman.
But the attorney, are you an attorney for the plaintiffs? Oh, you're a plaintiff, okay. Yeah. Well, I'm going to call on you, okay? So thank you.
But I just want to make sure that there's no confusion about why we're here and what so we're here because of the Milligan and Castor plaintiffs.
Mr. Chairman.
I understand. Yes, sir, Senator.
I also wanted to be clear as well is the fact that in this process there are two phases. The first phase is what the court has addressed. This is a totally independent phase that's dealing with remedy. And I think if you read those orders, they will address remedy totally independent from the fact that they've decided on this particular case. And because of that, it's not a bridge that carries over. It's a bridge that got us over. Now we're over here in the remedy phase. That's a whole different process in terms of us. The court is going to apply strict scrutiny to the process in which we put together. And because of that, those procedures and processes have to be addressed just as much as the fact that what got us to this point. Thank you.
Thank you. With that, I would like to, ma'am, the plaintiff, would you like to address the committee first? You are a plaintiff in the case, correct? Okay, let's start with those three plaintiffs. If you'll come. A little extra time. So please come forward. And I need you to stand at the microphone, announce your name very clearly for everybody to hear. And I'm going to give you 5 minutes.
Be sure to speak clearly.
Yeah.
Good morning or good afternoon. My name is Evan Milligan.
Well, I'm going to give you 5 minutes each.
Really?
Oh, yeah. We want to hear from you. So, yeah, give 5 minutes each. That's fine.
Sure. Well, do all of you have copies of the letter that was submitted into the record today? Okay. What's the best way for me to get them to the folks on the panel?
We'll get copies and send them out.
Okay.
Have you got copies?
Yeah, there's enough for every member of the committee. If you just hand them the envelope, then they can sort out the distribution. But thank y'all for hearing from us. We won't actually take the whole 15 minutes you've allotted, I don't think, right? But we want to say we are, as one of the members just indicated, our case was the one that the Supreme Court ruled on in terms of hearing our argument about the opportunity districts here in the state of Alabama. The three judge district court panel held unanimously that there was evidence of racial polarization in voting here to a degree that without opportunity districts for Black voters in the state, you wouldn't have an additional, you wouldn't have Black voters here in Alabama outside of District 7 able to elect a candidate of their choice. That ruling, that was from the lower district panel. And when the Supreme Court ruled on June 8th in our favor, they affirmed that lower court's ruling. The map that we're presenting to this body is one that features 2 opportunity districts. It addresses other issues with the with HB1, with which the map that we filed the lawsuit against, particularly in regards to cracking the voting strength of black voters in the black belt. So the map that we're producing actually keeps whole the 18 counties that form the core of the black belt. They're either placed in District 7 or District 2 of our remedial map. So that addresses the cracking problem. And this is also a map that splits it only splits 7 counties and 10 precincts. It doesn't touch the northern part of the state as far, I believe that's districts 4 and 5 in the Huntsville area and around Decatur. So this is a map that we're keeping, what you already voted into law in 2021. It preserves the northern part of the state. And the alterations to the map actually mirror what this body did with the State Board of Education map as far as uniting Mobile with Montgomery and some of the other alterations. We feel like this is a map that keeps the state of Alabama on the right side of the Voting Rights Act. It addresses the issues with our current congressional map that the lower federal panel took issue with and found out of compliance, and then also that the Supreme Court also recognized we're out of compliance with Section 2 of the Voting Rights Act. And we strongly urge you to consider our remedial map. Thank you for giving me the opportunity to speak. We hope that the materials we provided are also helpful.
Thank you so much, Mr. Milligan. And you are, sir?
I'm not quite as tall as Mr. Evans, so I'll lower the mic. Good afternoon, ladies and gentlemen. My name is Bernard Simonton. I'm president of the Alabama State Conference of the NAACP. The NAACP is one of the plaintiffs' organization in the Allen versus Milligan case. And we are here today to express our full support of the map that has been approved by all the plaintiffs and submitted by our lead attorney. So we want to be sure that you all understand the plaintiff's map and that it has the full support of all the plaintiffs. The plaintiff's map also meets the standard that the Supreme Court has laid out for as what's required, what will be required as we redraw these maps. The SCOTUS Supreme Court ensures that African Americans are able to select or elect a person of choice when it comes to representing them in Congress. And we want to be sure that everyone understand that these maps will certainly give people of color, African Americans, the opportunity to select the person of choice that will represent them in Congress and be able to work with them in the district in which they live in. We are urging the Redistrict Committee and the Alabama legislature later on to adopt this map so that we can move this process forward and be ready for our next election. The NAACP and its members across the state of Alabama and the plaintiffs look forward to working with the Redistricting Committee to answer any other questions that you may have through our attorneys so that we can meet the deadline that has been set by the courts of the United States of America. Thank you very much.
Mr. Simonton, just to correct the record for a second, make sure it's clear. You said the map, the remedial map that's been handed out, the one titled VRA Plaintiffs Remedial Map, is supported by all the plaintiffs. And am I correct in understanding you meant all of the Milligan plaintiffs?
Yeah, all the Milligan plaintiffs,
okay,
right.
Thank you. And do you know if it's also supported by all of the Castor plaintiffs?
Yes.
But you don't speak for the Singleton plaintiffs?
No, we're not speaking about the Singleton.
Thank you very much.
All right, thank you.
Thank you.
Good afternoon, Mr. Chairman. My name is Letitia Daniels Jackson. I'm one of the plaintiffs. And for the benefit of those in attendance and those watching, I would like to actually read into the record our letter that supports our remedial map and particularly lays out all of our claims, all of what we are trying to accomplish. I know you have a copy, but everybody doesn't. So I would like to read it into the record if it's okay with you. Is it okay with you?
Yes, ma'am.
Okay. Dear Apportionment Committee members, Evan Milligan, Shalala Dowdy, Letitia Jackson, Kadita Stone, Greater Birmingham Ministries, and the Alabama State Conference of the NAACP, collectively known as the Milligan Plaintiffs, and Marcus Castor, Lakeisha Chestnut, Bobby L. Du Bois, Benjamin Jones, Rodney Love, Manasseh Powell, Ronald Smith, and Wendell Thomas that are collectively known as the Castor plaintiffs jointly submit the attached remedial plan. As you know, on June 8, 2023, the Supreme Court of the United States ruled in favor of both the Milligan and Castor plaintiffs in holding that Alabama's 2021 Congressional Redistricting Plan, HB1, violated Section 2 of the Voting Rights Act. No other group of plaintiffs have successfully challenged HB1. Because the Alabama legislature's enactment of this plan would likely resolve the pending case, we urge the committee to give careful consideration of our VR plan. In affirming the three-judge district's preliminary injunction against HB1, the Supreme Court upheld the district court's findings that quote, Black Alabamians enjoy virtually zero success in statewide elections, that political campaigns in Alabama have been characterized by overt and subtle racial appeals, and that Alabama's extensive history of repugnant racial and voting-related discrimination is undeniable and well documented, close quote. The court also held that the district court had quote, faithfully applied our precedents and correctly determined that HB1 violated Section 2, close quote. The Supreme Court also affirmed the findings that the elections in Alabama were racially polarized. Quote, on average, Black voters supported their candidates of choice with 92.3% of the vote, while white voters supported Black preferred candidates with 15.4% of the vote, close quote. And according to all the trial experts, racial polarization in Alabama is, quote, intense, very strong, and very clear, close quotes. Given the extreme degree of racially polarized voting in Alabama, the trial court's preliminary injunction order, which was upheld by the Supreme Court, emphasized the practical reality that any remedial plan will need to include two districts in which Black voters either comprise a voting age majority or something quite close to it. For this reason, any plan that proposes remedial districts in which Black voters constitute less than a voting age majority or something quite close to it almost certainly will not conform to the district court's order. The VRA plaintiff's remedial plan carefully adheres to the decisions of both the United States Supreme Court and the Federal District Court. The Voting Rights Act plan contains two districts that perform consistently for Black voters in primary and general elections. It also remedies the cracking of the Black belt community of interest identified by the courts by keeping the 8 core Black belt counties together within these two remedial districts, does not split Montgomery County or any other core Black belt county, and has 0 population deviations. And then I'll move forward to our final. Indeed, the overall core retention, in addition to that, we, for instance, we leave districts 3, 4, 5, 6, and 7 are largely maintain the core of the districts as drawn by the legislature in HB1, and districts 1 and 2 reflect modest changes necessary to bring Alabama into compliance with the Voting Rights Act. Indeed, the overall core retention percentage of the Voting Rights Act remedial plan is over 80%. In further deference to the legislature's past policy choices, the VRA plan splits Jefferson County in essentially the same manner as HB1, and it splits Mobile County similar to the way in which the legislature did so in its enacted 2021 State Board of Election Plan. Finally, the VRA plaintiff's remedial plan is based on the plaintiff's illustrative plans, including Cooper Illustrative Plan 2 and Duchin Illustrative Plan A, which the Supreme Court identified as legally acceptable remedies, but makes the specific changes to better reflect legislative choices like limiting the number of counties split and protecting district cores. For these reasons, the Milligan and Casper plaintiffs strongly and respectfully urge the legislature to adopt our plan. Thank you.
Thank you so much for coming today. And I will now recognize for 3 minutes people who have signed up. And the first person will be Trey Bruce.
Good afternoon. My name is Trey Bruce, and I live in Birmingham, where I was raised. Graduated from Vestavia Hills High School in 2016 and then Auburn University in 2019. I'm here today just to share my opinion as a citizen regarding the redistricting of Alabama, not with a particular group or organization. I had the privilege when I was at Vestavia High School to learn from a wonderful teacher named Amy Maddox, who taught me for 2 years in U.S. history, as well as in a program called We the People, a mock congressional hearing program that taught us the importance and relevance of constitutional principles to the governance of our nation. And she really instilled in all of us students that even if we didn't end up going on to be historians or lawyers or politicians, that all of us needed to be active and informed citizens. And so that is why I'm here to give my public testimony. For as long as I have known what congressional districts were and was taught that in school, Alabama's map never particularly made sense to me in the way that 25 to 30% of our state's population is made up of Black individuals, and that only one of our 7 districts presented an opportunity for Black people to choose the representative of their choice. And of course, as we know, on June 8th, the Supreme Court ruled that Alabama's congressional elections in 2020 likely violated Section 2 of the Voting Rights Act. I have had a chance to review the letter and plan that the Milligan and Castor plaintiffs have just shared with you and just discussed, and it makes a lot of sense to me. Again, some of the key points that they pointed out: this would allow for 2 majority Black districts in the map, 2 opportunities for Black individuals in our state to elect the representative of their choice. They indicate that there's 80% core retention with this map compared to the previous map. And this would also keep protection for all of our Black Belt counties. So for all of those reasons, I'm in support of what is known as the VRA plan presented by the Milligan and Castor plaintiffs, and I look forward to seeing our state move in a direction that is more representative for all of our citizens. Thank you.
Thank you so much. The chair now recognizes Travis Jackson of Montgomery.
Thank y'all for allowing me the opportunity to speak. Reapportionment Committee, my name is Travis Jackson. I'm a Black Lives / Voter Matter activist who volunteers with a organization by the name of Rolling to the Polls, a voting rights advocate group of like-minded people driving voters to their proper or accurate voting locations. Also, I am an Iraq veteran. I mention this because I fought for the rights of all Americans, and that includes Black voters. In this testimony, I would like to elaborate on the importance of drawing more minority voting districts. I'll do so by explaining Black voters' obstacles. Black voters have always been the major factor for a much broader democracy. This is a proven fact throughout our American history. When it pertains to repairing human or civil rights, whether that's voting, healthcare, education, employment, housing, and feeding our neighbors or homeless people, Black voters were and have continued to become the political superheroes within our economy. On June 8, 2023, the U.S. Supreme Court declared the current Alabama voting district map, which was made in 2022, is discrimination towards Black voters. The Black, or as we call it, the woke vote, has always been under attack by the Alabama government. Even though the Voting Rights Act of 1965 was signed into law, Alabama voters are still to this day facing systemic racism, voter suppression, or as I like to call it, Jim Crow 2.0. A prime example of voter suppression or Jim Crow 2.0 towards Black voters to this day is strict voter ID laws. These type of voting laws have influenced a decrease in Black voters' turnout. In return, white voters' turnout has definitely increased. Under these unethical laws, it is a requirement to show specific photo ID. According to a Brennan Center for Justice data, 25% of Black voters don't have photo IDs, compared to 11% of all races combined. Other difficulties Black voters face on election days are lengthy lines, heavy police presence inside and outside voters' buildings, and being directed to incorrect voting locations. Also, I have experienced myself being misguided phone calls.
30 seconds, sir. Go ahead.
All right. 6 of Alabama's 7 congressional districts have a majority white voter population. Alabama's Black population is 27%. In the Pledge of Allegiance, it states liberty and justice for all. Therefore, Black voters should be in that word all through moral legislative action. Therefore, I strongly plead for the committee members to sketch a second reasonable minority district. This is 2023, not 1953. Thank you for your consideration.
Thank you so much. We appreciate you being here today. And the chair now recognizes Adia Winfrey from Talladega.
Good afternoon. My name is Dr. Adia Winfrey. I'm from Talladega, Alabama. In 2020, I was a congressional nominee for Congress in Alabama's 3rd Congressional District. I'm also the executive director and co-founder of Transform Alabama, a 501c3 dedicated to improving voter turnout and voter engagement using hip hop culture. Our organization was intimately involved in the redistricting process beginning in 2021. We helped mobilize people to the public hearings in Anniston and Calhoun County, Representative Boyd. And we had a great turnout and had voices from all over Talladega and Calhoun County expressing their concern with how the maps were drawn. This coalition was a multiracial group, a group that came from various backgrounds. So again, we've been watching this case closely. The SCOTUS decision on June the 8th, like so many times in Alabama history, has propelled the state of Alabama and the people of Alabama to the forefront of voting rights change. And like the last few centuries, we are the pinnacle of that change, but often Alabamians do not see the benefit. And my concern is that we are already seeing, we're less than 3 weeks out from the Supreme Court decision, and we already see how the plaintiffs in Alabama are changing the country and what voting rights mean in other states, but where does that leave us in Alabama? So what I implore each of you to do is put your politics to the side and put the people of Alabama in the forefront. I stand with the plaintiffs in the Milligan case. I stand beside this map, and I really implore you guys to make decisions for the people, because as the previous speaker stated, when Black Alabamians and Black voters are given the opportunity for their voice to be heard, everybody benefits. It's not just about 2 districts, it's about the entire state of Alabama. Thank you.
Thank you, Dr. Winfrey. The chair now recognizes Tyrone May from Jackson. Is Tyrone May here?
More, but I didn't sign up.
The chair now recognizes Rondell Roan from Fulton in Clark County. Okay. All right. That's fine. The chair now recognizes Felicia Pond from Montgomery. Okay. Chair, now, didn't Rondell James already talk? Rondell James from Montgomery? Yeah. Rommel. I'm sorry.
Good evening. My name is Ronald James. I'm the state organizer for Black Voters Matter here in the state of Alabama. We could stand up here and repeat over and over things that we already know. Numbers don't lie, and a great professor of mine once told me that if we don't know our history, that we will tend to repeat itself. Alabama has a history of being disobedient or not recognizing federal mandates in its history. We stand here today at the same precedence again with a mandate that's been handed down. We just ask that we follow the mandate, make the maps equal and fair. The maps that are represented here today by the plaintiffs, the people of Alabama, especially in the Black Belt, which we be most affected by how these maps are drawn, support these maps. We're not begging for anything. We're just asking to have a fair shot. A fair chance to represent people in the district that's going to represent what we look like, the minds and the concerns of the people that are in those districts. Don't split us up, keep us together. Let us be effective so that we can push Alabama forward, because when we all vote, when we all win. So thank you so much for hearing us today. We ask you that you do what's right, that we continue to do what's right, and let's push Alabama forward progressively together.
Thank you so much for being here today. The chair now recognizes Dr. Joe L. Reed from Montgomery. Welcome, Dr. Reed.
Thank you, sir. To the chairs of this important committee, to the members of the committee, to all who are listening. My name is Joe L. Reed. I'm chairman of the Alabama Democratic Conference, the Black Political Democratic Caucus of Alabama. I'm also vice chair for minority affairs of the Democratic Party of Alabama. And I appreciate the opportunity to come before this committee and express some thoughts I have about the plan. Before going further, I want to commend the plaintiffs in this lawsuit. You'd be commended for moving forward. I always thought we would win, and I got to collect my stake from one of my friends who told me we wasn't going to win it. I told him we would win it, and I'm going to get my stake pretty soon. And I want it to be a real good stake and not some little stake. Back to the real issue. I have been privileged about the last 45 to 50 years of participating in reapportionment plans. And by and large, we've been very successful. I worked with everybody I possibly could to get plans done, and one of the most enjoyable times I had to work with someone was Speaker Jimmy Clark of Barber County. It was amazing that Speaker Clark used to chair the Sovereignty Commission, and yet we put together a reapportionment plan that never left Montgomery County, Alabama. It was approved by the state courts. I want to mention 2 or 3 things about this plan. I'm going to try not to repeat what others have already said. We believe that, we know that the plan has to be constitutional, got to protect the one person, one vote. We understand that. We also realize and accept the fact it got to be racially fair. Now, let me say this, with all due respect to everybody here, I'm not here to down any plan. I'm here to promote a plan. My goal is very simple, is to get 2 majority Black safe districts. That's what I'm here for. To ask the legislature to pass 2 solid majority safe Black districts.
Call this person, I'm gonna call it.
Anything less than that is a hollow log. I've looked at some of these other plans, and I must say that in all due respect, I differ with it. Because I noticed one of the plans and the one that my friends have introduced, one is about 51% black in voting age, but you forgot to count the prisoners. There are prisoners in these districts, and these prisoners can't vote. And that's going to reduce the voting age population in these districts. That's very important. We saw what happened in Grimsley District down in Henry County when you reapportioned the Alabama legislature recently. I'm not condemning his opponent, nothing like that at all. But we saw he had represented that district for some time. But the minute it changed just a little bit, he was what? Gone with the wind. So I don't believe that we got a safe black district in the second district. I don't believe that. And we're going to, the Alabama Democratic Conference is going to advance a plan. And I understand we got some time to draw some lines. We're going to advance a plan that gives us a little more help than these other plans do. I'm not condemning, I'm not fussing at you, nothing like that. I'm talking about I'm a results person. I'm for the results. And that is what, when the end comes, when the sun goes down, at the end of the day, what do you have? And my point is, unless we have a majority voting age population, a sizable one, we will have nothing. And I'm not mad with anybody at all. But you got to be real and do a reality check. Also, there are some kind of lines that don't have to be, you don't have to split them. There are some splits, yes, necessary splits. I've drawn some in the past where I split some kind of, and I'll draw some more. Our plan that we have had split some kind of, but there are some unnecessary splits. Because there are some arguments over who's going to get Sugar Hill, Hopper Valley, and Peyton Place. That's irrelevant here. What we want and what we need, and I'm going to stop with this, we need a clear, safe, 2-majority black districts, not with 1% here and 1% there, 0.5%. I'm talking about something that's realistic. So I want to say again, Mr. Chairman, we're going to submit something to you. I want to say to the plaintiffs, I thank you. You've done a good job, and I want to commend your lawyers for it. I know some of them I know very well. I don't have no fight. I just want results. And right now, I have not seen a plan yet advanced that would give us the comfort in getting 2-majority black districts to the United States Congress. And Alabama Democratic Conference will be one. And I will say this. I would also encourage to the plaintiffs, we need to just sit down and talk. We all on the same wavelength. We're all trying to get the same thing. So we don't have a fight. Let's sit down and talk and try to put one together. We all get behind. And we know, and I'll say to the white legislators here, we know there are going to be 2 black districts.
Thank you, Mr.
So why don't
Reed.
you help us?
And I look forward to seeing you on July the 13th, where we'll put your plan up on the screen. If you'll have it submitted by 5 p.m. July the 7th.
Thank you, sir.
And I know you will. Thank you so much, Dr. Reed. I'm going to take a moment and recognize Mr. Jim Blackshear from Birmingham for.
He deserves it. Give him a hand.
Jim, I'm going to do you like I just did Dr. Reed. I'm going to give y'all 5 minutes because y'all are so deeply involved.
So, thank you very much, Mr. Chair. I too want to congratulate.
Can I get the clerk to change the map to the plan that Mr. Blackshear? Do you want your plan up there, Mr. Blackshear?
Yeah, if
you'll convert the map for me, please.
Donna to put the.
Is that it? I think that's it.
That's it. That's
okay,
it.
Thank you.
Thank you. Yeah. This is the map that's up on the screen now is the map that the Singleton plaintiffs are supporting. The Singleton plaintiffs' constitutional claim is still pending before the district court. It's consolidated with the other 2 cases, Milligan and Castor. In the victory in the Supreme Court establishes that the plan enacted in 2021 violated Section 2 of the Voting Rights Act, but it did not address what the remedy should be. However, the Supreme Court did affirm the ruling of the three-judge district court, and I need to read from the district court's opinion as follows. This is the injunction that this legislature is going to have to enforce. It's because there was a violation. We know there have to be 2 opportunity districts in order to correct the Section 2 violation. But those opportunity districts must also satisfy the Constitution. And here's what the pending injunction says. If we determine that the plan violates Section 2 of the Voting Rights Act, that would not be a determination that the Milligan plaintiffs are entitled to a map of their choice or to one of the remedial maps submitted to establish the first jingles requirement. Those maps are illustrative maps submitted for the purposes of establishing liability under Section 2 of the Voting Rights Act. The legislature retains flexibility in their work, subject to the rule that a district drawn in order to satisfy Section 2 of the Voting Rights Act must not subordinate traditional districting principles to race substantially more than is reasonably necessary to avoid Section 2 liability. And the question then before this committee is, what plans can they enact that will at once provide a remedy consistent with Section 2 of the Voting Rights Act, and 2, still comply with the Constitution? And the governing case is Cooper versus Harrison, Supreme Court 2017, that says that this committee must have a strong basis and evidence to conclude that Section 2 demands such race-based steps as splitting counties along racial lines. The state must carefully evaluate whether a plaintiff could establish all the jingles preconditions, including effective white bloc voting in a new district created without those measures. And we see nothing in the legislative record that fits that description. So what I'm pointing out here is that, and the lawyers can provide better explanation of what this is referring to, but this committee, in addition to adopting a plan, has to make sure it has before it evidence that it does in fact perform as an opportunity district. And in Cooper versus Harris, the Supreme Court looked at election returns to see how the districts performed in past elections, determine whether or not candidates favored by black voters won that district, could win that district. So the Singleton plaintiffs introduced early on in the litigation, in fact, back in before this committee convened in October of 2021, 3 plans, the whole county plans that we stand by. 1 minute. But the Campaign Legal Center, in a brief submitted to the Supreme Court, adopted or proposed this map called the CLC map number 1. And it provides 2 opportunity districts without splitting a single county along racial lines. Jefferson County, Mobile County, Montgomery County. Tuscaloosa is split the way the legislature split it in 2021 in order to equalize population. All of the Black Belt counties, except for Barber, are in 1 district, not 2, but 1 district. And the second opportunity district is Jefferson County itself, which depends on crossover voting with white voters in Jefferson County. Jefferson County is the one county in Alabama that has demonstrated that there is crossover voting that can support black candidates' choices. So I point out that problem to the court, to the committee about how it must follow its work and what the rules it must follow in doing this work. Thank you.
Thank you, Mr. Blackshear, and I know we'll see you on July the 13th. No, we're not going to. Today's just input from the public.
Can we not ask a presenter a question?
We did. All right, I'll let you ask a question, Representative England. Well, it's a public hearing, so let's go. Ask a question.
We ask witnesses in public hearings questions.
Okay, I'm sorry. I'm sorry. Ask the question, Mr. England.
Mr. Blackshear, could you come back up?
That's his map right there. It was actually in your folder. It's one of the singleton plans that we sent you. It's in your package. It's one of the singleton plans in your package, yes.
It says singleton congressional plan.
Representative England.
Yeah, I'm not going to keep you long. I just want to make a very clear distinction. Your case, the case that you represent, it's still pending, correct?
We represent the singleton plaintiffs in a case that's still pending before the three-judge court and has not been, our constitutional claim against the 2021 plan has not yet been addressed, yes.
All right, so you aren't a party to the case that we're here on, like what got us here, correct?
No, we are consolidated. We are parties in the consolidated litigation, and we are parties to what remedy is adopted by the three-judge court.
All right.
Yes, sir.
Mr. Walker asked you a question initially that said, or not asked a question, you a question, but asked the other presenters a question saying, whether or not you agreed with or were presented with the maps from the Milligan and Castor plaintiffs. Have you seen those maps?
Yes.
All right. Do you agree with those maps?
I agree that those maps provide opportunity districts for black voters, but I have my doubts about whether it could satisfy strict scrutiny under the Constitution because of the way it splits Mobile and Jefferson County along racial lines.
All right, but the question is, you do not agree with the maps from the Castor or Milligan, the map that was presented from the Castor and Milligan plaintiffs, correct?
It's not a question of whether I agree with it or not. I think it's a good map for the purpose for which it was drawn. I'm just saying that I don't believe that it's going to be able to pass strict scrutiny if it goes before the three-judge court for that decision.
And you say satisfying the standard of strict scrutiny because why?
Because it splits counties along racial lines to achieve a racial target of 50% plus one.
But each map that you presented also does that.
No.
Well, I mean, because Tuscaloosa is split.
Tuscaloosa is split, as are 5 other counties, in order to accomplish zero deviation. And that split in Tuscaloosa County was not drawn by us, but by this committee back in 2021.
So you would agree that in order to satisfy the Voting Rights Act, you are allowed to split precincts, split counties, and whatever's necessary to accomplish that objective. I think that's actually dicta from one of the opinions.
As long as it's not done along racial lines, the splits have to be done to accomplish zero deviation.
Doesn't one of the maps you present actually have small percentages of deviation?
No. Well, Singleton 1 and 2 had deviations that were not zero. Singleton 3 has a zero deviation.
The purpose of that deviation?
This one here has a zero deviation. The CLC plan.
So 2 of the plans that you presented, the purpose of the deviation was to attempt to find a way to satisfy the Voting Rights Act requirements, correct?
I'm sorry, say again.
So the 2 of the maps that you presented had small deviation in an attempt to try to satisfy the requirements of the Voting Rights Act, correct?
No.
So why did you have deviation in those 2 maps?
You're talking about Singleton 1 and Singleton 2?
Yes, sir.
Well, because Singleton 1 was drawn without splitting a single county for any reason. And by the way, this is something that's not going to be taken up at this time, but this committee needs to know that you can draw a plan that keeps all the counties whole and produces 2 opportunity districts, but Singleton 1 had a maximum population deviation of 2.47%. 2.47%. And the Supreme Court has said if you had adopted that, it's likely that that would have satisfied the Supreme Court standard for equal population in congressional districts because it's done to keep from splitting any counties. You know, this state did not have congressional districts that split a single county from 1819 until I guess 1965, when the first plan was drawn in response to Westbury versus Sanders. So for over a century, no counties were split. And the good thing about that is that it means that districts are drawn according to political communities, the counties themselves, and it helps constrain gerrymandering of any type. It doesn't prevent gerrymandering.
I'll ask you just this one question and I'll let it go.
Sure.
So,
sorry, I'm sprinkling.
Why did over the course of time, why did we increase the number of counties being split?
Because Westbury versus Sanders was developed by the Supreme Court in subsequent cases in the 1970s to say you had to achieve close to 0 deviation for congressional districts only, not for House and Senate districts, not for state board districts, not for county commission or school board districts. But just for congressional districts, the Supreme Court was looking to require 0 deviation, plus or minus 1 person. And that necessarily requires splitting at least 6 counties. Every map out there that you've seen has to split at least 6 counties in order to accomplish 0 deviation.
So I just want to make sure we understand that splitting counties and deviation is allowed when it's necessary, correct? Is that correct?
When it's necessary to achieve population deviation, that's correct.
Okay. Because I don't want anybody walking away from this process believing that we are required to have 0 deviation and no county line split. Because again, we're trying to accomplish the objectives of the Voting Rights Act.
Yep.
We are afforded certain deviations and also splitting of precincts and counties to accomplish that objective. I just want to make sure we all understand that as we go through this process.
Representative England, you are preaching to the choir. I'm only pointing out that you've got a problem when those splits are done intentionally along racial lines.
Mr. England, Chair now reckon, is there anybody else has a question for Mr. Blacksher? Thank you, Mr. Blacksher. I'm sure we'll have further discussions on July the 13th. With that, I believe we have Mr. Walker. Did you have some questions that had been emailed in or comments?
I do. Let me read the 2 comments that we've received over the course of the hearing. One is from Kay Smith. Dear Redistricting Committee, I would like to add my support to the plaintiffs and other speakers and their suggested remedial map to fairly represent the voters of Alabama. I submit that as a white voter in Birmingham, I too have felt a lack of representation for many years now. I would hope that the new plan would give progressive voters like me, regardless of race, a voice at long last. Thank you for considering this suggested plan. The other comment that was received is from Tiffany West. In the redrawing of the congressional map, I would not support a map that shrinks Congressional District 7. I would, however, support a map that includes all of Jefferson County and Tuscaloosa County and Black Belt in District 7 and all of Montgomery and Mobile in District 2. Those are the comments I have, Chairman Pringle.
Thank you so much. The chair now recognizes Mr. Mike Bunn from Baldwin County.
Yes, sir.
Thank you. If you'll Tell us what you're here to talk about, sir.
Just a little historical perspective for what it's worth. I was asked about this. I run Historic Blakely State Park, and
would you speak into the microphone?
Run Historic Blakely State Park.
We have several hundred people watching us online.
Okay. So I'm in the Mobile-Tensaw Delta, and just want to point out, historically speaking, that's been a united community for a long time. If you go back in all the colonial eras, which you don't need a whole history lesson. I write books, and I won't bore you with all that. But if you go all the way back from the 1700s up until when the battle that was fought at our park was actually in Baldwin County, but was fought defending the city of Mobile. So I was asked a little bit about that, and just for historically speaking, we've been a united community on both sides of the bay for a long time. We've even had a history of ferries running between the communities for a long period of time before the Cochran-Africatown Bridge was built and opened in the 30s that united those communities a little bit more efficiently than the ferries. So that there's a little bit of a community on both sides of the bay that I think we're very cognizant of down in Mobile Bay region.
Thank you so much for being here today.
Thank you.
Why don't I say that? Why don't I say Yeah. Just forgive me, but Chair now recognizes Rodricia Russo from Dothan. Did I butcher that? I'm sorry.
Good afternoon. Hi, my name is Rodricia Russo Glasgow. I am the Executive Director of the Ordinary People Society, Normus Tops, also board member of Alabama Ford, and Vice Chair of 2nd Congressional District, ADC, Alabama Democratic Conference. I am here and standing with our plaintiffs on the the Milligan versus Allen plan that has been presented before you. I just wanted to raise a couple concerns of mine, specifically because, as we know, Mr. Joe Reed explained how this affects those that are incarcerated in our prisons specifically. And as we know, in 2008, NAACP Legal Defense Fund held the back of Pastor Glasgow on the Glasses versus Allen lawsuit against ADOC for those that are incarcerated to be able to vote while they're in prison, as long as they did not have a crime involving moral turpitude. Why is that important to today? Because there's still thousands of incarcerated people who are eligible to vote inside of the prisons, and unfortunately, because of the lack of voter education, they are voting from where they're housed and not where they live in their particular county, increasing prison gerrymandering, which is my concern. Some of the maps that I have seen specifically splits into some of the highest populated counties, particularly in Elmore, where there's 1,154 inmates, Limestone, 2,302 inmates. Montgomery really didn't break down. I didn't see too much variance in Bullock, but I just, for the numbers record, Bullock has 1,485, Wallace 714. And so, as we know, Alabama is still among the 5th states in the United States that has the highest incarceration rate. I ask that you would adopt this map on behalf of the plaintiffs, because it also shows that it is not cutting the district lines, particularly impacting those that are eligible to vote within those districts. And so I thank you for hearing us today, and we look forward to the upcoming meetings that we have. Thank you so much.
Thank you so much. The chair now recognizes Mary Williams from Montgomery. Next person, David Russell from Birmingham.
I'd really just sign up to just let them know, keep the numbers high,
But whilst I'm here, I do make quite few observations. I love what the senator from Mobile stated, that at least when you're doing the president, vice president, at least we should have had a minority in one of those seats, because it is not what it is, but what it's projected to look like outside the public. It appears that the public probably would see that, you know, even though these are 2 black districts, but yet still we have 2 white chairpersons. So I wish you all would kind of look at those appointments again. So if you have a white chair, at least we can get a black vice chair. Thank you.
Thank you. The chair now recognizes Gregory Clark from Birmingham.
My appreciation to the chair, committee members. I'm J. Gregory Clark, representing Faith in Action, Alabama. We are a multi-faith, multiracial organization whose mission is to dismantle systemic racism in order to produce pathways of opportunity for every Alabamian. Today, I implore you to draw congressional maps that empower and give voting power to Black and brown communities in Alabama. For far too long, minority communities, particularly Black and brown citizens, have faced significant obstacles in exercising their right to vote and achieving fair representation. Historical injustices and systematic barriers have hindered our ability to fully participate in the democratic process. But we stand at a critical juncture where we have the opportunity to right these wrongs and ensure that every voice is heard. We must acknowledge the painful history of voter suppression and disenfranchisement faced by Black and brown communities in Alabama. Our communities have persevered, fought for our rights, and contributed immensely to the fabric of our state. It is time to recognize our resilience and address the long-standing inequalities we continue to face. Drawing congressional maps that give voting power and representation to our communities is not only a moral imperative, it is a legal obligation. We must uphold the Voting Rights Act of 1965 and protect the rights of minority voters. To achieve this, I urge this committee to prioritize the following principles in the redistricting process. First, we must ensure that Black and brown communities are not fragmented or diluted through gerrymandering tactics. By respecting the geographic, cultural, and socioeconomic boundaries of our communities, we can allow for a cohesive representation that truly reflects our interests and needs. Secondly, majority minority districts must be established to empower our communities to elect representatives who understand our unique experiences and concerns. It is through these districts that we can overcome historical barriers and provide opportunity for underrepresented communities to have our voices heard. Transparency and public participation are paramount. I implore the committee to conduct the redistricting process openly, engaging community organizations, advocacy groups, and residents in meaningful dialogue. Finally, I implore you members of the Alabama Reapportionment Committee to seize this moment, to be on the right side of history, and to draw congressional maps that give voting power to Black and brown Alabamians. Together, let us build a future where every Alabamian has a voice, where fairness prevails, and where our democracy truly shines. Thank you for your time.
Thank you so much. We appreciate you being here today. And now the chair recognizes Donald J. Williams from Montgomery. Yield. Mr. Williams yield. Now the chair recognizes Byron Evans from Selma. You yield. Mr. Walker, do you have any more comments that have come in on the email address?
Chairman Pringle, I don't have any other comments. Oh, wait, I've got one.
Yeah.
Late arrival. This is from James Butler. I'd like to leave a comment to the committee in this hearing that I hope that the map which I, James Butler, proposed to the committee in an email earlier this week is shown to this committee. I believe its compactness and ability to secure 2 opportunity districts would satisfy the plaintiffs of both cases. That's all I have.
Are there any additional comments while you're here? Yes, sir. Please come forward and state your name, and you'll have 3 minutes.
Thank you most graciously. My name is Frank James Matthews III from Birmingham, Alabama. And I kind of touch a little tenets that the good legislator, consummate politician, Joe Reed mentioned initially when he first spoke about convicts. And then the young lady just spoke again about the population of the prisoners and the handicaps that faces us. I was arrested 11 years old in the county jail in Limestone, Alabama, had a criminal career with some 38 arrests. But out of all that, I turned the lemons into lemonade. I walked down Highway 22 and 80 and picked up paper like Michelangelo painted a picture as a convict. And one day I had a premonition and I seen myself as sold my rights to vote to the prison system. I was able to change my life in prison, got an early release from prison, and of all people, Governor Guy Hunt gave me a pardon. And I was able to run for elected office. I ran for mayor, I ran for city council twice, and I ran for state representative first. I ended up being the first black person that happened to be a black man that got in a runoff in District 2, there in the city council of Birmingham, Alabama. And to this day, no black person has gotten that seat. The young people, a black population, majority. The older black people, a majority population. But what they did, when I ran for state representative and almost got in a runoff, missed it by 200 votes with Oliver Robertson, they changed the district from way at the top of the Birmingham map and went way to almost the bottom of the Birmingham map and brought in enough of Shelby County, which was literally white. And I like 200 votes from becoming the first black man, the first convicted black man to be a council person in District 2. What I say, I want to say to the NAACP, I want to say to all these other groups, you better count your numbers and who has a propensity for voting, okay? So if you don't have a propensity for voting, you can have the black, young, you can have the older blacks in the district and still have white representation. So I suggest that you go up there in North Huntsville, in that area up there where Miss Hall is, because the black people in that area have a high propensity for voting. So you can do the same way they did to me, way down in Shelby County, got that living cotton, picked that cotton and rode it down the river and kept me from being elected. So that's one of the things you better make sure. Don't say it's just black. Don't say it's just young.
Mr. Williams, that's 3 minutes.
Count your votes before you go at them. Thank you very much.
Thank you. Is there anybody else who would like to say something before we conclude this public hearing? With that, the public hearing is closed. We stand in adjournment. Oh, I'm sorry. I didn't see you.
It won't take but a second just to say something because I learned something
sorry.
here. Dr. Reed made a profound statement when he talked about look at these districts and make sure people can vote. I'm from a county that has a prison, and right next door, Barber County has a prison. I see these prison numbers in these maps. We need to make sure that we have people in these communities that can vote, a voting age, and going to be able to do something. So I'm looking forward to seeing your map, Dr. Reed, and thank you all for allowing me just to say that brief word to this committee. Let's make sure we got something in our vote.
We need your name.
John McGowan, County Commissioner, Bullock County, District 3.
John McGowan. Thank you so much, John. All right, with that, is anybody else? I don't want to make that mistake twice. We are adjourned.